Please make sure you mute yourself if you are not speaking.
Good morning, I am in.
Okay, Ingi. Dr. Swanepoel, you're good to start the meeting.
Good morning, everybody. I'd just like to make a short welcome speech. On behalf of Professor Brian MacArthur, the Acting Deputy Vice Chancellor of the College of Law and Management Studies, and Mr. Adrian Bellinger, the Acting Dean of the School of Law, I wish to extend a warm welcome to our speakers today, in particular, Advocate Mkhwebane, the President of AOMA and the Chairperson of the AORC Board. She will also be presenting. And I wish to also extend a welcome to our facilitator, the Honourable Mr. Sanyang, and our speakers, the Honourable Ms. Nyerere and the Honourable Ms. Malera, the Ombudsman in Gambia, Rwanda, and Malawi, respectively. The School of Law has had the privilege of being associated with the African Ombudsman Research Centre since 2011, and I'm pleased that the centre continues to provide a platform for debate and discussion in this important area. The law of evidence forms a key part of the branch of procedural law, also known as adjectival law, and the subject forms part of the LLB curriculum. We also supervise students in this area at master's and PhD level. And importantly, the law of evidence overlaps with other branches of procedural and substantive law, such as criminal procedure and civil procedure. So the topic of today's webinar is of great interest to lawyers, legal academics, as well as ombudsman institutions. So I think it's highly topical and straddles a number of fields. So without further ado, I'd like to hand over to the President of AOMA, who will now deliver her welcome address. Thank you.
Thank you so much, Paul, Mr. Swanepoel. Thank you for welcoming us, and we always appreciate the assistance We received from University of KwaZulu-Natal. Pass our regards to Prof. MacArthur and the acting Dean of Law. Thank you to Honorable Sanyang for facilitating today. The Ombudsman of Gambia. Thank you to my colleagues, Honorable Nirere from Rwanda and our colleague from Malawi. Thank you so much. As the Ombudsman, as the President of the African Ombudsman and Mediators Association, you would know that this association constitutes of more than 40 countries. We then have the various regions which are represented in our executive committee. Secondly, we also then have the African Mediators Research Center, which we have the very capable leadership there, Frankie and Marion, who always organize these seminars and webinars, and we benefit a lot, especially ourselves as ombudsmen, and especially our various officials. I must indicate as well that these webinars and seminars assist us to improve our investigations. Hence, today we will deal with the issue of evidence and how we handle the evidence, how we collate the evidence, how we preserve the evidence. And some of the institutions like the Public Protector, where our remedial actions are binding unless set aside by a court of law, that's where we will have to make sure that when we are taken on review, that evidence is indeed the evidence which is preserved, the evidence which is reliable, the evidence which will have to be availed and kept properly. And in the long run, as these ombudsman institutions would want to make sure that when we deliver our services and when we assist and hold government to account, we ourselves, our house is in order. We have all the standard operating procedures, the processes, investigation manuals and investigation models, which we will have to follow to make sure that when we conduct investigations, they are credible, they can stand the test of time. In doing that, we will be able to assist various countries and African Union members to achieve aspiration dealing with good governance, and that will then make sure that there's proper administration, good governance, the resources of the state is used for the benefit of the public. Therefore, we will have to make sure that we are capacitated ourselves. But as Mr. Swanepoel has indicated, that this engagement will also assist law students in how to preserve and in how to apply what they've learned through the law of evidence. And further, we hope there are public servants who are here who will also learn how we conduct our investigation and how critical it is for them to keep the records which they are having. So with those few words, thank you so much to everyone who's participating, the organizers, those who are hosting this seminar. I'll hand over to Honorable Sanyang, the facilitator, to take us through. Thank you.
Please unmute yourself, Honorable Sanyang.
Hello, are you hearing me now? Hello?
Perfectly.
Yes,
Thank
perfectly.
you.
Yes, okay. Thank you very much, our President, for these welcome remarks, and also for setting the stage for the discussions that we are about to happen now. As we all know, the topic today is managing evidence. And I think you've properly highlighted why it's so important for the work of an ombudsman. And today we have 3 presenters. And I think without wasting time, let me just start with the first presenter, who is going to take us, whose talk is going to focus on the types of evidence and admissibility requirements of those evidence. And that's going to be presented by Honorable Madeleine Nireri, who is currently the Ombudsman of the Republic of Rwanda since 2020 in November. Previously, she has been the chairperson of the National Commission for Human Rights of Rwanda for 8 years. That's between 2012 and 2020. She also chairperson of the Network of African National Human Rights Institutions, 2017 to 2019. She has also been a member of the Global Alliance for National Human Rights Institutions, that's 2015 to 2020. She also worked with the Parliament of Rwanda for 13 years under the Chamber of Deputies on different senior positions. She has also been the Deputy Secretary General of the Upper Chamber of the Parliament of Rwanda between 2009 and 2012. She has extensive experience in human rights at international and regional level and significant experience in monitoring rights of inmates and detainees, and also extensive knowledge on national preventive mechanism. She holds a master's degree in international criminal justice and law of human rights, LLM, a master's degree in public administration from ENAP, Quebec, and also a bachelor degree of law and a postgraduate diploma in legal practice. So I think with that brief introduction, may I now welcome Honorable Madeleine Nireri to make her presentation. Thank you. Madeleine, are you hearing me?
Thank you so much, facilitator. Good morning, everyone. Thank you so much for giving me this opportunity to make presentation on types of evidence and admissibility requirements. But before that, I'd like to thank the organizing team of African Ombudsman Research Center for the great work done and for organizing this webinar. I'd like also to express my sincere gratitude to the president of the AOMA and AORC, head of anti-corruption authorities in this webinar, and also distinguished participants to this webinar. My presentation will be, as mentioned, on types of evidence and admissibility requirements. Regarding the outline, I'll talk about the role of Ombudsman Mediator's Office in collecting evidence. I'll be talking about a little bit on evidence management. Then I'll come up with the type of evidence. Also, I'll be talking about how to present and support the case in court. Also, admissibility of evidence. Then strength and challenge in evidence collection. Then conclusion. I start by defining the role of Ombudsman and Mediator's Office in collecting evidence. For our work of collecting evidence, we have to have a legal framework and other system, the procedures which facilitate to collect evidence. For example, in Rwanda, we have laws on 2004 relating to evidence and its production, and also other mechanisms and procedures. We have digitalized procedures and system, and there are asset declaration of assets, and verification of assets declared, which can be source of evidence. We can also use informant. We have a law on on protection of whistleblowers. Also, we need international cooperation to gather evidence, especially in the transnational crimes, the corruption crimes. We need also a partnership with national institution. For example, Rwanda Bureau of Investigation, National Prosecution Authority, Rwanda Revenue Authority, the office in charge of lands, the office in charge of registration of companies to collect all kinds of evidence. There is also a need of close collaboration with civil society. For example, yeah, we do collaborate closely with international Transparency International. Next, regarding the evidence management, first of all, I'd like to say that evidence is a demonstration of the truth. Therefore, it must be collected in a manner which does not compromise its nature, and it must be kept in a way which maintains its nature. Also, it must be handled in a way which allows, and no doubt. And also, next, as mentioned, the law on evidence of production in Rwanda, in its Article 9, state that an evidence based on legal issues on fact can be proved by written evidence, testimony, presumption of circumstantial evidence, admission of party, or another material evidence. This is our law. I will be talking about other laws and case laws. And there are some principles. In the criminal cases, evidence is based on all grounds. Also, which is different from civil cases. The law prohibits the production of some evidence, for example, one based on mixture, ordeal, witchcraft, or any other magical, mythical, or esoteric means. That's the prohibited evidence. Also, another principle is that the court rules on the validity of the prosecution or defense evidence. Another principle is that evidence collected under torture are prohibited. That the law, even international laws, prohibit such kind of evidence. Next, regarding, next slide. Regarding the type of evidence, we can have many types of evidence, but mainly there are 4 types of evidence. That are what we call real evidence or physical evidence. Related to things or used in the case. For example, gun, vehicle, or money used for bribery. They can have demonstrative evidence that demonstrates testimony given by a witness. This can use diagram, maps, etc. We can have testimonial evidence or witness testimony about a statement by a witness. There is as said by Mira and Ross, in the forced arrest and first imprisonment in 2018, testimonial evidence is viewed by the court to be simplest type of evidence. We have also documented evidence, which is a type of evidence that help to document the issue being discussed in the trial. We can also have expert evidence. Sometimes we need expert evidence, and it is used to assist the court when the case before the court involves matters on which it does not have the requisite technical specialist knowledge. admissible testimony relating to a professional, scientific, or technical subject. I can say that expert evidence is based on formal and special study or training or experience that impart the competence to form an opinion upon matters associated with the subject. Next slide. I'm trying to be quick to, there is what we call hearsay evidence. In the principles, hearsay evidence is not admissible, but can help court in some cases. I took the case of Pedro in the hearsay rule in its exception, California law review, that said that in the admissibility of hearsay, that courts should be governed by realities, that hearsay evidence has not been subject to the test of accuracy and veracity, and is of inferior value to the testimony of witness to whom those tests have been applied. There are also many reasons that have been advanced by judges and text writers on the basis for exclusion of hearsay evidence, that some of them are the lack of oath, the danger of error in its transmission, the lack of personal knowledge by witness or the fact declared, the lack of opportunity for cross-examination is the real basis for exclusion. That's the hearsay evidence, which is not, even in Rwanda law, hearsay evidence is not admitted. But there are some exceptions in which the judge can depart from the information and finding other, constructing other evidence. Also, when we are talking about evidence, we have direct versus indirect or circumstantial evidence. For example, to obtain a conviction for a corruption and money laundering crime, which is in our area as the Ombudsman and Mediator's Office, it's very difficult to find direct evidence. They are only available in rare cases. Corrupt officials and money launderers often use the service of skilled accountants and lawyers to assist them in forming complex financial structures. Or even if bank records show that a person received a sudden increase of cash into his account or her account, the owners remain on the prosecution to find the link that connects that cash to the unlawful activity. That is an issue, in fact. Now, I wish to highlight the evidence in the case of corruption, because it's our area, the prevention and fighting corruption. When you are using direct evidence, it is about proving the existence of a particular fact with any inference or presumption of being required. And for indirect or circumstantial evidence, it relates to a fact or matter or series of facts or matters, often that the particular facts that are sought to be proved. When offering indirect evidence, it is necessary to argue that such evidence by reason or experience is so closely associated with the fact to be proved that this fact may be inferred from the existence of what is indirect or circumstantial evidence. Indirect evidence is, of course, used in the full range of criminal cases because, as mentioned, the evidence of all ground are admitted in criminal cases. Okay, next. In this spirit, we can good practice show that financial and direct evidence is regularly used in complex corruption cases. Sometimes an investigator may be able to link special financial transaction directly to the criminal conduct that is being alleged, However, even when financial transactions cannot be directly linked, evidence of assets movement, property of purchases, or unexplained wealth may itself, or if other evidence, give ground to believe that the assets or wealth concerned come from an illicit source. In the corruption investigation, the following source can be provided: and direct evidence, can use financial operational audits, can including assets, lifestyle, expenditure. You can use expert evidence. You can use testimony given by an accomplice, etc., etc. Next. Yeah, for collecting evidence, there's a series of questions we have to ask yourself and find solution. In principle, the outcome of presentation, evidence presentation, is to prove beyond reasonable doubt. This is the principle. The prosecution has an obligation to answer the following question. Here I say prosecution, but an officer within the office of ombudsman or mediator has obligation to answer the following question, even when is in the case of complaints, solving, or case of corruption or other cases, we have to answer the question, what happened? The offense and its commission must be clear. When this, when the offense has been committed, also who committed the offense, why the offense has been committed, also how the offense has been committed, and where, to determine the area. It must be clear in the statement, and also to see what are the victim of this offense, to whom the offense was committed. This is a question that must be answered to gather, to collect evidence. Also, next, those are the principles. There are some exceptions. In fact, the general principles is that the prosecution usually be a legal onus of proof. The burden of proof beyond reasonable doubt is one of the prosecutor. But there are some exceptions, even in a case of corruption, the reversal of the onus of proof. In fact, the general principles may be expressly reversed by the legislation. We have these principles, but exceptions also are necessary. For example, in the case of illegal enrichment offense, the accused proved that he or she acquired the asset legally. That is the reversal of the onus of proof. The person, it is about the person to prove his or her innocence by disproving a fact that the prosecution would normally be obliged to prove. Next, regarding the admissibility of the evidence. For the evidence to be admissible, it must be relevant, material, and competent. To be considered relevant, reliable, it must have some reasonable tendency to have proof or disprove some fact. And it is up to judge or jury to determine the appropriate weight to give to a particular piece of evidence. When we see the international human rights law about the admissibility, the admissibility of evidence require a balancing between the interest of individual and the protection of his fundamental rights, right to the liberty, right to fair trial, right to defense, and the power of sovereign state. This is very important because when gathering evidence, we have to also to proper balance between interests of individual and in protecting the fundamental rights. Also, we have Article 25, paragraph 2 of the protocol establishing African Court of Human and People's Rights, which provide that country may receive written or oral evidence and other representation, including expert testimony, and it shall make a decision based on such evidence and representation. This requires international cooperation. Also, Article 30, paragraph 1 of the Statute of International Court of Justice stipulate that the court shall frame rules for carrying out its function and lay down rules of procedure. And there is a case of admissibility of unlawful obtained evidence before International Court of Tribunal. The ICJ has not fully exercised the rule of admissibility of evidence. Consequently, all evidence is admissible, and the court is free in assessing the probative value of it. Just to some cases, and also to show that it is up to the court and the jury to assess the probative value of evidence. Next, we have some challenges. We have some strengths and challenges in evidence collection. Some strength is political will of zero tolerance to corruption to facilitate collection and apprehension of offenders. This is also very important. We have also the laws institution ombudsman and mediator's office, which provides some more powers, especially fighting against corruption. There's some powers, including collecting of evidence, also prosecuting some cases for, there are some ombuds office that have this mandate of prosecution or judicial power police. Also, there are laws which regulate evidence production. Also, the cooperation between African Ombudsman and mediators, which is very important. For example, for transnational crime, cyber crimes, and the other crimes, international crimes. There are challenges in collecting evidence. There are some offenders that use the IC tool to hide their criminal acts. So this makes it difficult to collect evidence. There are also cyber attacks. There are criminal network. There are citizens reluctant to report corruption cases. And this is, I think it is common. Corruption is underreported in many countries because of fear of reprisal or yeah. To conclude, I can say that no country is immune from corruption, and the governments need to work together and with partners from business, civil society to tackle it successfully. Also, the anti-corruption bodies need to strengthen their cooperation with national and international organizations with its mission to fight against corruption. And this where gathering evidence and prosecuting case of corruption. Also, there is cooperation of the ombudsman with other organizations in collecting and presenting evidence, and as a tool to recover assets and to win the fight against corruption. And I would like to end my presentation by a quote of our president, which show that the fight against corruption relies on the high-level political will of zero tolerance to corruption. Where President Paul Kagame says, there can be no doubt that corruption is very costly to both governments and the businesses and as such impacts negatively on our development efforts. It therefore makes economy sense and good political to fight. There can be no doubt that corruption is very costly to both governments and the businesses, and as such impacts negatively on our development efforts. It therefore makes economic sense and good politics to fight corruption. Equally, not in doubt is the fact that success of the fight against corruption depends on good governance. End of quote. Thank you so much for your kind attention. The question raised will be answered after our presentation. I have some more insight on the question raised. Thank you so much.
Thank you very much, Madeline, for this very rich and detailed presentation. And I think some of the points that we want to carry home would be how you've dealt with the role of the ombudsman in collecting evidence, whether it's in the area of declaration and verification of assets, or the use of informants. Normally we call whistleblowers. And I think this is important because I think one of the questions that have been raised concerns how such whistleblowers are protected. Maybe when it comes to answering questions, you may want to deal with that. You have also dealt with how we can get information to our international organizations and international corporations. You've also dealt with evidence management, the types of evidence. But I think this depends very much on what the domestic laws of our different countries see in connection with the evidences that can be presented to court and things like that. So that was also a very, very rich and enlightening presentation. You talked about real evidence, how demonstrative evidence, and also testimony evidence, and also expert evidence, as well as hearsay evidence. Because normally these are the sort of categories of evidence that you will receive whenever a case is reported to you. And you've also talked about how you present and support the evidence you have to support a case in court. That's also very broad. And I think when we have your slides, a lot of us will learn a lot from it. Not only what you are doing, but what we can also take away from those presentations to see how we can influence whether it's going to be the laws of our different countries in respect to how we operate as Office of the Ombudsman. I find that presentation to be very, very useful. And you've also explained about admissibility of evidence. That's also will depend on the court system in the different countries, but I'm happy that you've also indicated some or made reference some cases that have been handled in your country to give us an idea of what sort of evidence you may want to prepare yourself with when you want to defend cases in court. Another important thing you talked about are the strengths and challenges. I think these are very important because besides all these laws, there has to be those challenges that we have to overcome. And the most important thing you've already highlighted is the political will for zero tolerance. And I am happy that you cited an example by quoting what your president said, Paul Kagame, concerning the corruption. And I think that's the sort of the political will that all countries or all offices of ombudsmen expect from their respective countries. Then, because as you rightly said, corruption is not easy to fight. There's always a common saying that when you fight corruption, corruption also fights back. So I think we are mindful of that, because if we are unable to overcome corruption, especially in our own institutions, there's little we can do, to show our worth in the work we do. So with those brief remarks from the presentation, I now want to proceed with the second speaker, who is going to take us through evidence gathering, analysis, and also evaluation of such evidence. And that's going to be presented by Honorable Grace Tikambenji Malera, who was appointed as Ombudsman of Malawi in September 2020. She's a lawyer also and a human rights expert with 19 years of work experience working both state and non-state actors. She has worked across the governance sector in Malawi on a broad range of thematic areas, including human rights broadly for gender and women's rights, children's rights, and access to justice. She holds a Bachelor of Law degree, LLB honors, obtained from the University of Malawi, Chancellor College in 2002, and graduated from the University of the Free State, Republic of South Africa, with a Master's in Law degree in 2007. She was called to the Malawi Bar in 2002 to practice law in both the Supreme Court and High Courts of Malawi and courts subordinate thereto. She has vast experience working with regional and international human rights organizations at the African Commission and human rights level, respectively. She served as a member of the Special Law Commission on the review of electoral laws 2016-2017, as well as a member of the Special Law Commission on the development of the trafficking in persons legislation. She is an exceptional human rights and gender advocate. She's an architect of some NGOs working in the governance as well as in the advancement of women's rights, and serves in a number of boards on human rights NGOs in Malawi. She is passionate about using the law as a tool for social change and attainment of social justice and gender equality and inclusion. In 2019, Grace was the moderator of Malawi presidential debate ahead of the 2019 Malawi tripartite elections. With that short bio, Grace, you are now invited, please, to make your presentation on the evidence gathering, analysis, as well as evaluation. Thank you.
Thank you so much for the kind introduction. And I would like to also thank the organizers for inviting me to be a part of this process as a panelist, and to recognize all my fellow panelists and everyone that has joined. I'm meant to present to pick up from where Honorable Madeline has left, and zero in on the issue of evidence gathering, analysis, and evaluation. As offices of, as ombudsman offices or public protectors, mainly, how do we go about gathering evidence? How do we go about carrying out the analysis and the evaluation? So by way of introduction, I'm stating that for offices, ombudsman offices or public protectors, I think evidence gathering is one of our core functions. When we look at our establishing statutes, be it in the constitutions or be it in acts of parliament, I think as Honorable Madeline already stated, there are clear provisions in those statutes that give us the power to carry out investigations, because this is one of the critical avenues for actually resolving complaints on acts of maladministration that are lodged by various people with our offices. So this is an important aspect of our day-to-day work. And essentially, it is the quality of the evidence that we gather that also determines the quality and credibility of the outcome of our reports. I picked a common saying in information, communication, and technology: when you're working with a computer, what you put in is what you get out. So they say garbage in, garbage out. In other words, the accuracy, sufficiency, and appropriateness of our evidence will then determine the objectivity of our reports, and more importantly, whether we are going to have people that read our reports as offices of ombudsman and say, yes, that is a credible report. And another hallmark in evidence gathering that I would like to highlight at the outset is that it is important to remain objective as far as possible. And also this enables us to arrive at a just and fair. I think the last thing we want as officers of Ombudsman is to have, the common person on the street questioning the very fairness of the reports or determinations that come out from our investigation processes. I think that would be a reversal of the order, because primarily people come to our offices to seek justice, to seek fairness. So our reports should be a reflection of fairness and justice in its totality. Hence the importance of ensuring that we go about gathering the evidence, analyzing and evaluating it in the most professional and objective manner. So what is evidence gathering? Basically, this is a process of collecting all potential evidence. It can be oral, it can be documentary, as Honorable Madeline already said, but the idea is to provide a factual basis for developing our findings. So we heard from the area presenter where they were talking about issues of hearsay, issues of circumstantial evidence, and how all that fits into the body of evidence that we collect. But the underlying principle that we work with in evidence gathering is a collection of facts. We want to collect a factual basis, and it is that factual basis which then takes us to making findings and issuing the reports that we issue. Essentially, when we are gathering evidence, this is aimed at aiding the ombudsman or the investigator to prove or disprove any matter of fact raised in a complaint. Remember, people will come to our offices with complaints, making all kinds of claims and allegations. Oftentimes, they may not even bring the supporting documents to support their claim, and aimed at arriving at a just and fair conclusion of that issue. What we are doing basically is to then go about and substantiating that allegation, collecting all the facts that surround the allegation or the complaint, so that either, number one, we can arrive at a conclusion where we are proving that what they are complaining about is true, or actually disproving to say with our findings. So I go on to say that it is therefore critical to start with a planning phase. And this is always the important point in evidence gathering. And here I want to use my own example. I worked in the Malawi Human Rights Commission for 16 years, starting off as a legal officer and then rising through the ranks. What I saw back in the day is, people may now call it old school, where literally an investigation plan by an investigation officer had to be approved by a director or a supervisor. That emphasized the importance of planning. What I saw over the years in the Human Rights Commission and now coming and joining the Ombudsman Office is that I no longer see that level of preparedness on the part of the investigators. I don't think we are much more detailed. Maybe with the coming in of technology, you don't see, rarely an investigator that has sat down to literally go through the process of planning. And yet there's a common saying that says, when we fail to plan, it's as good as failing to implement the activity that we want to do. So maybe we can go back to our procedures and encourage our staff members to really focus so much on the planning phase. It is at this planning phase that the investigator or ourselves as ombudsman can set out the framework for conducting the investigation. That's number one. Number two, we can also at that point set out the terms of reference, the scope of our investigation. How far do we want to go? What do we see as the limits of the investigation? In the planning phase, as we are preparing to go and gather the evidence, we also focus so much on understanding of the subject matter of the complaint. I think I'm not speaking for the Malawi Ombudsman Office, maybe I'm speaking for so many ombudsman offices where the kind of complaints that we receive are so diverse. One moment you are handling a complaint relating to a public service delivery that is not delivering to the expected quality, or that is not responsive, or that is not accountable. The next moment you are receiving a complaint from an ex-public service officer who for some reason have not received their gratuities. Or the next moment you are looking at how maybe government process the, certain financial proceedings. So it is important at the point of planning to clearly understand the subject matter of that complaint. A quick example that I can give, this office, the Malawi Ombudsman Office, carried out a critical and strategic investigation into how the government of Malawi facilitated a deal of procuring what we found to be archaic and updated farm instruments. And instead of putting those farm instruments to their intended purposes, they were actually sold amongst senior ranking officials in government, but also amongst some members of parliament. And the ombudsman had to go and investigate. At that planning stage, it was important for the office to understand clearly how parliament functions, how the relevant line ministries, in that case, the Ministry of Agriculture and the Ministry of Finance function, and so on and so forth. So it is at that planning stage where you understand what roles, what are the mandates of the responding institutions, because that then helps you to understand exactly the areas that you need to probe into, but also the issues that you need to raise with which institution. There's also a need to come up with this investigation plan because it helps us to keep checking if we are on track with our investigation. I've already talked about mapping. An investigation plan also helps us to map who we are going to contact and the reasons that we are going to contact them. I have added here something that I learned from outside accountability offices like the Office of the Ombudsman. In another capacity where I worked, it was also always imperative to come up with a sort of risk assessment to anticipate what obstacles are we likely to meet and how are we going to circumvent them. So all that can happen at the planning stage, and wherever possible, where our manuals allow, we also need this investigations plan to be approved by supervisors. At the planning stage, we also look at what laws, what regulations we are going to need to consult or to have reference to in order to carry out our investigation. I now do the techniques of evidence gathering. There are a number of ways of gathering our evidence, as we all should know. With improvements in technology, sometimes it takes as simple as a telephone call to alert an institution about your investigation and to dig out more in particular preliminary issues around the issue that we are investigating. We have on-spot investigations where this is where now our officers actually go on the spot to the concerned officers to talk to the respondents, to engage them. As they are doing that, they are gathering the facts that we need. And at that point, which we must always insist as officers of ombudsman, is documentary evidence, because when we look at the strength of evidence, the different modes of gathering evidence, documentary evidence is one of the most reliable and accurate means of getting evidence. So when we go to those offices and we are interacting, if they make reference to things that were documented in minutes of meetings, in reports, in files, in accounting books, it's important to ask for those to be given to us. When you look at our statutes that establish offices of ombudsman, you actually find that we have specific powers to do that. And when people do not comply, there's also ways that the laws give us power to actually enforce. At this stage, I must emphasize that if the complaint is not in dispute, if the facts that the complainant have raised are not in disputes, this is also a critical stage where some of those issues can be resolved there and then, where the responding institution, say Ministry of Education, acknowledges that yes, there were some lapses and this is how we want to fix. But because in our modus operandi, we must always hear both sides. At that point, don't rush to conclude, get back to the complainant and tell them the ministry is willing to resolve the issue. These are the proposed remedies. What do you think? So that they can also input into how justice or fairness would look like to them. We need to note that most ombudsman statutes or procedural manuals provide that all investigations must commence with ombudsman providing a notice of investigation. I think this only goes to highlight the point that if we are a place where people come to seek fairness, this fairness is not just in the eyes of the complainant, in the eyes of the public, but it must also be in the eyes of the responding institution. So that notice is to actually alert them that, look, we have this complaint against you. These are the kind of issues that would like you to respond, so that they must also feel that this is a process that is following due process. Another technique for our evidence gathering, as we all know, is tripartite meetings. This could be a second stage to on-spot investigations. Yes, you have gathered the preliminary facts, but you feel that there's need for dialogue, there's need to finding out more. And this is where you convene a roundtable discussion, and more evidence can also be gathered at this stage, where it is literally tripartite, and the ombudsman there is wearing now the robe of the mediator, properly so called, and the two parties are coming together, reconciling their facts, and with the aid of the ombudsman. It is important to remain impartial and any actual or perceived conflict of interest. And then we have a fourth technique, which is the public inquiries. For most of our statutes, again, this is provided for in our laws. There's actually a power there for offices of ombudsman, public protector, to convene hearings through public inquiries where parties can come to testify. And this is where we gather the type of evidence that Madam Madeline referred about to, which is testimonial evidence. And normally, the inquiries are constituted under the powers stipulated in Ombudsman's office's governing statutes, and the proceedings are held under oath. The other methods that we can use are interviews or focus group discussions. Madam Honorable Madeline already talked about expert opinion. Right now, I'm doing a hearing where the issue of a signature and handwriting is in contest. This is a woman that is claiming that she never got deceased the monies when her husband passed on. Yet we have a district council office that has brought to us documentary evidence with a purported signature of the deceased's wife, who is also now deceased, to have collected the money. So we are at a point where we are saying, look, as an office, we do not have handwriting experts, people that can interpret signatures. So we are looking around. In other instances where we have commonly used expert evidence is when people present to us certificates, when there are claims that they were hired dubiously and they present to us certificates, we must have recourse to expert institutions like the National Council for Higher Education in Malawi to verify the authenticity of certain qualifications that people present to the Office of the Opinion, so of the Ombudsman. So expert opinion renders our reports much more credible and much more authentic. We can also gather documentary evidence. This can be through letters, through looking at policies and existing laws. One key area that I see the role of the Office of the Ombudsman being more strategic is gathering evidence by way of systemic investigations. This is where now we are not waiting for a complainant to move us, but we are studying, we are going beyond ordinary investigations when we see that certain things are so systemic. We are looking at the patterns of maladministration, and then we want to see how government systems are run, what are the areas that are prone to abuse, prone to corruption. Not that you are investigating a specific individual, but basically the system and how it functions and whether it is geared towards quality service delivery or not. This office, the Malawi office, carried out one recently where we investigated into a tendency by our public hospitals to carry out procedures where women's uteruses were being removed when they go to seek maternal services, sometimes for avoidable reasons. But the conclusion was, you have this, go for, I think they call it a heterosectomy or something. So we investigated, we looked at the systems and we made recommendations. We also carried out systemic investigations on mental health facilities and the kind of service that people with mental disabilities receive, because there was poor service delivery, and we made recommendations. So there are many areas where we can go beyond investigating on a daily basis, complaint by complaint, and going systemic. So when all the evidence is gathered, how do we go about doing the analysis and the evaluation? Here, when I was preparing for this presentation, I realized that there can't be hard and fast rules. We all have manuals in our offices, standard operating procedures. So I basically focus much on the principles, the standard principles that should guide our evidence analysis and evaluation. Evidence analysis and evaluation is basically a process of examining, integrating, and reviewing the evidence gathered to establish its credibility, the importance of that evidence, and how it connects to the issue being investigated. In other words, relevance. And you find that at that stage, you actually you may take out chunks and chunks of evidence because maybe it is not material to the issue under investigation. This stage also contributes to success of any potential court process, as an accurate evidence gathering will be less likely contribute to a reverse of a decision. I think most of us, the laws that set us up provide a power of review of our determinations by the courts. I hope I'm not speaking only for the Malawi situation. So when an aggrieved party reads our report, our determination, and they feel like they don't agree, they can go to court to seek review. It is at the point of analyzing the evidence, evaluating and gathering it, that we can build a report that even the courts should be able to confirm and be on the side of the ombudsman. And I think we have seen this in a number of cases where the courts in different jurisdictions in South Africa, we read a lot of jurisprudence from there where the courts have agreed with the ombudsman. But that can only happen when our evidence is credible, when we demonstrate that we operated fully objectively. So when we are evaluating our evidence, we are checking basically the following: the accuracy. Is it accurate? Is what we're finding, is it true? The credibility, the weight that one would attach to the kind of evidence. So I'll go back to what Madam Honorable Madeleine said about the evidence that sometimes your full report is just based on hearsay. That one said, oh, I heard from the general manager. You haven't talked to the general manager. Everyone is citing the next person, and your full report is built on person X said to person B, but you haven't gone to the actual first-hand information person. I wonder whether that could lead to a credible report, a reliable report, and a relevant report. You are investigating a matter, like I said, if we don't understand the subject matter, we go on bringing into the report content that is not really speaking to the issue that we are investigating. The evidence analysis stage is also where we link the evidence and facts to prove or disprove a claim, like I mentioned in the introduction. And this is also done by measuring the facts against the legal principles. So there's that part in our analysis where when all the facts are laid out, you then go, because you are looking at, was there an injustice? Was there a maladministration? Was there abuse of power? were things, did things happen in an unreasonable manner? Were things done unprocedurally, and so on, all the things that we check. So you need to read all the applicable laws, all the applicable policies for you to arrive to prove or disprove a claim that yes, 1, 2, 3 things happened unprocedurally and so on. So it is always important in our evaluation to measure our facts against all the applicable legal principles. For me, I find this challenging because it means staying up to date with the legal provisions. I've suddenly realized I really need to catch up. What does the Electronic Transaction and Cybersecurity Act say for Malawi? How about this particular act in education, in environment, in health? So I think our officers must just be empowered, because ultimately this is where the crux of our reports lie, in looking at the applicable laws and making findings on whether there was an act of maladministration or not. How do we analyze the evidence? This is centered on checking the quality and reliability. It is also actually a confirmation of the quality of evidence. It is therefore important to know the qualities of a good evidence and check the evidence gathered if it is matching the qualities, and I've already alluded to the qualities. This include sufficiency. Do I really have sufficient grounds to prove this claim or to disprove it? And we find that I was doing a public inquiry that took 3 months, because at every stage we thought, I think we still need to go to talk to that particular officer in that office. When you talk to them, you still had a feeling of, is this really sufficient evidence to say we have fairly concluded this matter? Maybe let's go and talk to the governor of the central bank himself. When you talk to the governor of central bank, you still find something is missing. So I think a quick example for those of us that have gone into these trainings is where they talk of the onion or the cabbage. So trying to find out what is at the heart of the onion and peeling each layer by layer. With all the tears sometimes that come out when you're peeling an onion, until you arrive at a sufficient body of evidence on which you can base your findings. I already talked about accuracy and relevance. I've already talked about credibility of the evidence that we gather. When we check these qualities, it is possible to determine if all the evidence that we needed has been obtained, and then to go on to analyzing the evidence. I'll quickly go to the principles of evidence gathering, evaluation, and analysis. Very quickly, recognize and avoid conflict of interest. And I don't know how the different manuals and standard operating procedures that guides these processes make provision for declaration of conflict of interest. And then whether or not we go on to recuse ourselves from handling a particular investigation as an investigator. And then when it comes to the office of the ombudsman, for example, the challenge that I see, the ombudsman, him or herself, like in the Malawi scenario, is vested in the only one person. No deputy ombudsman, no nothing. In the event that I see that, look, this case has come to the ombudsman, but it is emanating from a body where I'm affiliated in other capacities. Do I declare that interest and proceed to handle that matter as objectively as I can? Or do I recuse myself? If I recuse myself, have I closed the door for accessing justice by those particular complainants? Because no other person other than myself can sit and do a public hearing on that matter, because the ombudsman vests in the person holding the title of ombudsman. I don't know how it works in other jurisdictions, but I thought I would flag this. What the main point I'm making is there must be seen that we are avoiding the conflict of interest. We must also ensure confidentiality. This is very important particularly in the present day workspace, where just with a click of a WhatsApp message, you can have a certain important piece of your investigation gone viral. to people that were not supposed to receive it. So how do we inculcate a culture of confidentiality in all our officers, and then observe procedural fairness? I already started by saying that when people are coming to our offices, they are looking for fairness. The last thing we must do ourselves is to perpetuate unfairness in our own procedures by not following the due process. So this entails informing all the people whose interests will be affected so that they can participate in our investigation processes. They can come and speak for themselves, providing parties with reasonable opportunity to put their case either in writing or hearing, considering all submissions carefully, avoiding bias, making reasonable inquiries, and more importantly, taking into account relevant factors and not irrelevant factors, and acting fairly without bias and avoiding undue delay. So in terms of the conclusion, I'm highlighting that every evidence gathering, evaluation, and the analysis process is unique. How it is carried out would depend on a number of factors, including what is being investigated, the potential sources of information, and the level of agency cooperation, the people that we are engaging with, the respondents. Because every process is different, it is not easy to stipulate a time limit within which the processes must be carried out and completed. However, we all know the legal maxim, justice delayed is justice denied. So this must be the overarching guiding principle in all our evidence gathering processes, in all our evaluation. I think a typical question I can pose is this really a process that should take 2 years? We are just feedbacking to the complainant, or we are still investigating your claim. We are still investigating your complaint. Lack of a speedy and effective resolution of complaints by the Ombudsman can cause unwarranted delay, can create a sense of frustration and unfairness, and a feeling of lack of efficacy, which adversely affects the public trust and the confidence in the Ombudsman's offices. More importantly, in all these processes, the Ombudsman or the officers must ensure that the following key principles are safeguarded. Number 1, transparency. Number 2, integrity. We must go about our evidence gathering process, analysis, and evaluation in a manner that actually upholds the integrity of these offices. We are not offices that can carry out haphazard work, substandard work, and non-professional work, because that actually is the defining character of fairness. So we must maintain standards of high integrity in all these processes, and accountability when my determination is taken to court for review. When my determination has been made public, am I able to demonstrate a process that followed all the due procedures and accorded the parties all their rights and everything else? And more importantly, am I able to demonstrate as Ombudsman that probably the decision that I've arrived at is a credible, is a fair, and is a balanced decision? So these are just some thoughts that I had on the issue of how do we go about gathering, evaluating, and analyzing evidence. I thank you so much for listening to me.
Thank you very much for that presentation, for that very good presentation also, Honorable Grace. I think you've also definitely built a lot on the first presentation in the area of evidence gathering and also how we use that evidence. But I think the most important thing that you mentioned is to remind us that our core function cannot be fulfilled without good evidence. So evidence gathering is definitely one of the 4 core functions of all offices of the Ombudsman. And the evidence we collect, you've said, should be of quality evidence, because if the evidence is not of good quality, the results will just follow suit. And during the evidence collection, we need to be focused and also remain objective. And because at the end of the day, our report should reflect who we are as impartial people, as professionals, as people who are just very objective in whatever we do. So that can only be achieved if we have from the beginning quality evidence to work with. And we also need to plan our investigations. Because our investigations should be thorough, we need to plan for it. And you've made some suggestions where there could be a need that anytime you plan your investigation, that you seek a second opinion if it's going to be your line manager, so that you share with him how you plan to go about that investigation. And that will probably happen if there are no operational procedures in the area of how such information should be gathered. But I believe in most institutions, there should be operational procedures of how you follow as soon as we receive the report, how you go about it to mount your investigation. And it's also important, as you said, that whoever is doing the investigation has a knowledge of the subject matter to be investigated. If it's going to be about an institution, you really know how that institution actually operates. That would be a plus to anybody who is doing the investigation. And as you prepare for these investigations also, you've highlighted that you should look forward to obstacles that you're going to meet whilst you're doing the gathering of these investigations. You've also talked about how you can use your telephone, just call when your complaints are lodged, so that the people against whom complaints are lodged know you are about to start the investigation. Or you may even conduct a spot investigation. And probably that would give you the opportunity to see how the office or institution is operating. And if possible, it will also give you time to inspect some documents if you want to, and also maybe files related to the complaint. And during the time of gathering, it's also important that you continue to work with the complainant. As you receive information from this, the body against which he has complained, that he should know the progress of your investigation, and may even be able to give you more insight on some of the information you've gathered from that institution. And if there's need, you've also highlighted there could be tripartite meeting, because after all, the ombudsman is only trying to solve problems as quickly as possible. So if it's going to be possible for the parties concerned to sit together and you mediate, I think it'd be better for all of them. You also talked about public inquiries. I'm not sure, because in some institutions, these things are held in camera. You don't have public inquiries as such. But again, if the law allows it, I think it's also going to be, a good idea. Not only that you are showing more transparency in what you are doing, but there's going to be more respect and more education in our activities. And another important thing you talked about is the systemic investigations. Now, these are important, but I just want to ask, because sometimes it has to depend on whether the statistics of reports or the complaints that are coming to your office is going to be the basis for your systemic investigation, or whether it's going to be the nature of the complaint itself that's going to create systemic investigations. Maybe when you're wrapping up, you may want to comment on that. And I think basically these are the things I have picked from your presentation, and that there should be the analysis in the, that you're going to, the information you have is be able to analyze it to know if whether it's going to be enough to support whatever decision you want to arrive at. And for us as officers of the Office of the Ombudsman, we should be mindful of the conflict of interest we talked about, the confidentiality of the job we do, and also how we how fast we handle matters. Because you've talked about a thorough investigation, but I don't think that should be the reason to over delay cases. As you have rightly said, there's always the saying that justice delayed is justice denied. But above all, I think you've hit on a nail that we should be very transparent in whatever we do, and high standard of integrity and also accountability. So I think these are very important lessons that we going home with. And with that, now I want to move to the third and final presentation. Actually, is going to be on the chain of custody and preservation of evidence. We've talked about how these evidence are being collected, gathered. So what's more unused, but what's also important is that how do we preserve this information for future use, like we've said from the beginning. If the issue is challenged in court, probably the evidence that had been gathered during the investigation is well preserved. So maybe we'll hear more on that from the Honorable Advocate Bisisui, who is the South Africa's fourth public protector and was appointed in October 2016. She is the current president of AOMA, of our own African Ombudsman Mediators Association, which is a continental body of public protector-like institutions. She is also the board chairperson of the African Ombudsman Research Center, which assists the AOMA with research, information, capacity building, and advocacy. In December 2018, she was elected the president of AOMA during the association's 6th General Assembly in Kigali. And I'm happy that she's going to be one of our presenters today. So, Madam, you are welcome. Thank you.
Thank you, Facilitator, Honorable Sanyang. To my colleagues, Ombudsman of Rwanda and Ombudsman of Malawi, you have dealt with a number of issues, which I think I will have to try and summarize with the 15 minutes I'm given, so that we can also then give our listeners or participants an opportunity to ask questions and to answer their questions. I'll start by saying condolences to the families of the KwaZulu-Natal floods disaster. And we have a serious challenge as a country now facing this disaster in the midst of the challenges of Corona. And as an institution and as the Ombudsman and Mediators Association, we hope you will assist us in the challenges we are facing. So my presentation will focus on how we then manage the evidence, the chain of custody and preservation of evidence. So there's a number of issues which have been addressed already, but then now I'll focus on the introduction, chain of custody, preserving evidence, a record of evidence for judicial review purposes, because we've heard the Ombudsman of Malawi indicating that our decisions will be taken on review. And when they are taken on review, will they stand the test of time? The next slide. There is a general consensus amongst the ombudsman-like institutions that the purpose of conducting an investigation is to obtain direct and reliable evidence to enable the public protector to make informed decisions about the veracity of a complaint, about appropriate corrective or remedial actions, and about the resolution or settlement of the dispute. So similar to other ombudsman-like institutions across the globe, you'd know that in South Africa, we are termed a public protector, but in other jurisdictions as mediators. So we focus normally in our investigations on what happened, what should have happened, and is there a discrepancy between what happened and what should have happened? And if so, does that deviation amount to improper conduct and maladministration? And in the event of improper conduct and maladministration, what would it take to remedy the wrong, or where appropriate to place the complainant as close as possible to where he or she would have been, but for the improper conduct or maladministration? The question regarding what happened is resolved through a factual inquiry, which has been addressed already, conducted with an open and an inquiring mind, relying on the evidence provided by the parties and independently sourced during the investigation. In South Africa, as Ombudsman Malera has indicated, we do have the Supreme Court of Appeal judgment, where the Supreme Court of Appeal said in the case of Public Protector versus the Mail and Guardian, which is a print media company, which in my view applies to all ombudsman or mediators type of investigation, which says the public protector must not only discover the truth, but must also inspire confidence that the truth has been discovered. It is no less important for the public to be assured that there has been no malfeasance or impropriety in public life. If there has not been, as it is for malfeasance and impropriety to be exposed where it exists. There is no justification for saying to the public that it must simply accept that there has not been a conduct of that kind only because evidence has not been advanced that proves to the contrary. Therefore, you should always rely on evidence. So evidence must therefore, in simple terms, be described as original, reliable source of information, as my colleagues have indicated, that will enable the ombudsman to independently and accurately discover and establish the truth. So in line with that, with our order of proceedings, I'm going to restrict myself to the chain of custody and preservation of evidence. What is also very critical is that we listen to the truth of the complainant, the truth of the institution. We ourselves have to uncover the truth after we've analyzed and investigated the matter, as my counterparts or my colleagues have indicated. Along with the subject matters covered in the preceding presentation, this chain of custody and preservation of evidence are at the core of effective investigation, which I will explain as follows. Therefore, as ombudsman, we shouldn't just rely on information or what the media or information is saying. We can take that as our lead, but we need to then go deeper, as it has been indicated by my counterparts. So the definition of a chain of custody that I came across while preparing for this session explains this aspect of investigation in criminal investigation terms. Admittedly, there is a vast difference between criminal and administrative action investigations, but there are similarities too. Accordingly, I've relied on the definitions. So the one definition is of the National Institute of Standards of and Technology of the US Department of Commerce, in terms of which the chain of custody refers to a process that tracks the movement of evidence through its collection, safeguarding, analysis, life cycle, by documenting each person who handled the evidence and date and time it was collected or transferred, and the purpose of the transfer. The other definition of chain of custody is, according to Just Criminal Law, a US-based law firm as well, the documentation that establishes a record of the control, transfer, and disposition of the evidence. So in a criminal investigation, police investigate, hand over the case docket to the prosecutors, who assess the evidence and enroll the case in a criminal court for trial. So the court then reaches a verdict, and if there is a conviction, imposes a sentence. So typically the criminal case docket will contain evidence, including the investigation diary or evidence log, accused and witness statements, DNA samples, photographs, documents, articles retrieved from crime scene, among other things. The evidence must be credible, and it must have not been tampered with or contaminated. So in an investigation that focuses on administrative action, which is our field, which is more of in our field as investigators and ombudsmen, is something akin to a judge and a jury all wrapped into one, because we investigate, we evaluate the evidence, and we put it to the respondent, make findings, and determine the appropriate remedy for consequence management and redress, or to remedy whatever prejudice which has been suffered. I think the Ombudsman of Rwanda, since they also deal with criminal matters and corruption related, and they can prosecute, that information is critical for them. So similar to a criminal case docket, our investigation file will ordinarily contain the investigation diary, an investigation plan, the complaint, correspondence exchange between the respondents' documents that have a bearing on the investigation, the notes, the photograph, videos, audio recordings, and transcripts of the interview. And in a criminal docket, the evidence must be credible. It must have been obtained through a lawful means, and if obtained from non-official sources, it must have been independently verified. So mishandling of the chain of custody can have dire consequences for an investigation. Those against whom adverse findings have been made can poke holes on the chain of custody as a strategy for successful judicial review of an investigation report. That's what we've experienced in South Africa, which we have a number of cases before court, which are taken on review. And what is critical is how we've kept our record and how the other party will then request the record, which we call Rule 53 in terms of the Supreme Court rules. So in one case involving donations made by the president, made to the president for a leadership contest with his own political party. Can I be excused a little bit? I think there was a excuse me about that. I think there was another call coming in. So in one example for a leadership contest within his own political party, which governs the country and has done so since South Africa gained freedom, he challenged the public protector's evidence gathering methods in judicial review proceedings. So he had denied being actively involved in fundraising for the election campaign and in managing the donations. So during our investigation, we then obtained evidence in the form of copies of emails from his own mailbox, providing the fact that he was actively involved. In court, he suggested that we obtained the emails illegally. We were also in possession of bank statements linked to the bank accounts, where the fundraisings and the donations were made, where he suggested that we obtained those illegally. But there was then proof from our side, because we have the power to subpoena any evidence, and there was proof that indeed we've subpoenaed the information properly. So I think it's very critical in the information gathering process to comply to that. So investigation record keeping is based on common sense. An investigation diary is kept in the file. The purpose of the investigation diary is also to keep record of what the investigator did. I think that one we've dealt with, or the Ombudsman of Malawi dealt with. So the investigation diary should also allow the manager or the supervisor to check whether the information has been collated and whether there's compliance to the investigation plan. I also like what the Ombudsman of Malawi also said, that we shouldn't be accused of delaying ourselves, because that investigation diary will also then help you to check whether your investigation plan or your project plan is online, you've collated all the evidence, you've analyzed on time, so that you also don't delay with your investigation. So the investigation diary also become an important document where the investigator leaves the office, and at least there is that file which has all the information, which is kept properly, because we know that we have young investigators who will also have to pursue their careers somewhere else. If that file is also properly kept, it's very critical. So apart from keeping copies of information on the file and making entries on the investigation diary of the file, the investigator is also required to keep a record and maintain information electronically. So the Ombudsman of Rwanda mentioned about the digitization of the information. In South Africa, we are finalizing our electronic case management system, which will also then help us to be more efficient, but to keep our record effectively. So the other interesting question is, I remember there was one case of the Reserve Bank versus the Public Protector, where the question was, we had even handwritten notes as part of the evidence which we have availed. So the question is, would you say the handwritten notes are not also part of the evidence? And when the Ombudsman is accused that, why didn't you record the session? So I think it's a question of making sure that the courts also understand that you might not have the systems to record, or you might be failed by electronic systems, but at least if you have a backup, or if you also have handwritten notes, that's proof and that's evidence that this is what transpired in a particular meeting. So the investigation file should be full of, it should be a full record of the investigation, and the record in the investigation diary should be supported by what is in the file. So most jurisdictions suggest that the following types of information will normally be included in an investigation file: a copy of the investigation plan, legible notes of what the investigator did, when, what was found, including notes of interviews, phone calls. So this has been dealt with by my co-panelists, and I think we should also then take that into consideration. The next slide. I'm pushing for my time now. So all this as well, it's what has been mentioned by my co-panelists. You can move to the next slide. And in cases where voluminous evidence makes up a distinctive part of an investigation, such as public hearings, which has been covered, that evidence can be kept in an addendum to the main investigation file, because we know sometimes we have piles and piles of evidence which we would have, and investigation file and records of investigation should be kept in a secured location. We know as well that you need to also have in your institutions the officials or your risk managers, your auditors, so that you don't lose the evidence, because sometimes you'll have floods. Now in KwaZulu-Natal office, we are affected by the floods. How do you keep all those records in a secure place and to prevent being destroyed by floods, being destroyed by fire? So that's also very critical. So that's how you secure the information. The next slide. So in jurisdictions like South Africa, where the decision of the Ombudsman is taken on review, we've mentioned that we have a number of cases which were taken to court. So in a South African jurisdiction, obligate that the file of record arises from Rule 53, one of the Uniform Rules of Court. Rule 53 deals with the judicial review proceedings, which are brought for the reviewing of the decision of the inferior courts, a tribunal, a board, or other performing judicial or quasi-judicial or administrative functions. So the decisions of the public protector are subjected to judicial review. And as you know that all of us, we conduct inquisitorial investigations. It's an inquiry, is not accusatorial. Therefore, we need to avail this information irrespective. The next one. Once any of the public protector's decision are taken on judicial review, the public protector is required to show to court or the aggrieved party how the public protector arrived at any of the decisions. This entails the public protector having to compile the record, which shows what evidence was relied upon to arrive at the impunged decision. So for this purpose, the record must be properly indexed. I think the lawyers will know that you need to paginate as well your record in a chronological order, the oldest date to the most recent, and it must only be properly paginated. That's very critical, that your evidence, any person who goes through that file can follow. Thank you so much for giving me this opportunity. I tried to do my presentation. I think I took 18 minutes of the 50. supposed to be 15 minutes. Thank you so much, Facilitator, Honorable Sanyang.
Thank you very much. And I mean, it was a very good presentation. I also building on what the two presenters had already mentioned before. And your own area is probably the conclusion of all the events that, having collected all the information, made your decision over the matter, you now want to keep these records so that anytime there's need for review, it can be easily available for anybody who wants to contest. And that it's important, as you said, that we understand during our investigations, when we say we are looking for maladministration, what are we actually looking for? And what are also misconducts? I think sometimes this could be very, broad issues, and you definitely need to tie it to the complainant's own version of the story. And you also need, as you have stressed, original and very reliable source of information, not only hearsay, because the credibility depends on actually whom you get the information from. And then you talk very well about this chain of custody, which means you need to show the track of the movement of evidence calculated from the time that it was planned to who collected the evidence, whom did he talk to, whatever is recorded, what documents are available to support your hearing. These are all things that need to be kept to a point that anytime there's a need, it can be brought out to support your decision or whatever. So, and it could include files, diaries, and maybe sometimes even electronic records, and as well as copies of your investigative plan. And finally, another important thing you talked about is how do we keep these files so that they are safe from fires, floods, or even unauthorized persons having access to these documents. So I think this is the summary you made on how we can preserve these documents and keep them for future use. So I think with that, we've now come to the end of the presentations. And Mr. Chair, I don't know whether now I can hand over to you so that you allow the speakers to answer some of the questions that have already been raised. Hello, Grace?
Yes, Facilitator, you can go through and request it's still your opportunity.
Okay, okay,
Yes.
okay. All right, okay.
Yeah. Close when we are done.
Okay, all right. So then let's go back to some of the questions that we are asked before the commencement of this program, and I'll invite the speakers, starting again with the first presenter. That's Madeline, to see what questions she wants to answer. Madeline, do you have a list of the questions that were asked that affect your presentation?
Yes, thank you so much, Facilitator. There are a number of questions. There are a number of questions raised before the presentation. There are a question regarding how can build a financial convincing evidence to support a non-compliance case involving poor reconciliation of accounts books. In fact, the financial convincing evidence or the rule is that the reconciliation, the bank reconciliation must be, there must be a proper balance between accounting books and bank reconciliation. In this, in financial cases, numbers accounts. Therefore, you can request the assistance of an expert in accounting to build a financial convincing evidence. That's for the first question. For the second question, there's someone who say that thank you for invitation to attend the event. And as I am not from a great continent for Africa, I'd like to ask, what role do you see for an ombudsman who is not from Africa continent, nor lives on African continent? I think, and I touched on it in my presentation, because the cooperation and partnership are very key when you need to gather evidence, when you need to tackle cases of corruption, transnational crime, recovery of stolen assets. This is very key to partner with. He may be helpful in helping in gathering information, exchange. Also that people which hide the assets out of Africa, the information may come from those countries. There is another question, how do we handle expert evidence in the absence of technical experts within the institution? Are there any case laws on the topic of the day which can be referred and applied as best practice? I think we touched on it in the presentation. In fact, evidence is managed in the manner which is not compromising its nature. And when we do not have a technical expert within a institution, we talked about, I think all presenters, about the partnership. We can, for example, find an expert for second opinion, for example. This can be also applied. There's another question on way of organizing administrative investigation file. In administrative investigation file, not typical standard way, but different researchers agreed on 3 methods of organization: chronological order, spatial order, and porters order. The fifth question is about, I'm very much knowing which evidence holds substance in the court of law or during hearing. We can depart from principles. For example, in criminal matters, all evidence is based on all grounds, means that all evidence counts, and the substance of evidence depends on each case. All evidence are admissible, and the court is free in assessing the probative value of it. However, we have what we call real evidence, in which we can count documentary evidence. This very important because it is the most common in criminal cases, and it is an evidence that build up the documentation of the events leading to the crime, often presented during the trial. This documentary evidence, as one of the presenter mentioned, is very important, either in criminal, even civil, and even in handling complaints. There's another question about the protection of a whistleblower, the person who helped with the evidence. In many countries, there are laws on whistleblower protection. In Rwanda, we have a law relating to the protection of whistleblower. There are some different measures to be taken to protect whistleblowers and the witnesses. Among them, there is a confidentiality. There's also concealing identities, not disclosing names. There is relocation. The court proceeding in camera is another. The court proceedings are held in camera. Also, there are sanctions provided for in the law on whistleblowers protection, including imprisonment or 3 years in the case of retaliation. Also, there is a immunity regarding disciplinary action to the one who disclosed information. That is a few questions, few answers I have. Thank you so much.
Thank you very much, Honorable Madeleine, for responding to those questions. And I don't know whether the other speakers also want to make some few comments, because you've almost answered all the questions that have been forwarded, but probably if we can hear something from Honorable Grace, you want to add something on, or you want to answer any of those questions? You can go ahead, please.
Thank you. I think Honorable Madeleine has done justice to most of the questions. Maybe just to add, that there was a question, not on the Q&A, but in the chat, where someone said, I'm not ombudsman in the African continent, but what role do you see that kind of ombudsman playing? I'm looking at areas of collaboration where we can keep exchanging standard operating procedures and best practices, so that these are living documents that must be updated at all times. In these days of electronic communication, for example, Honorable Kwebane already talked about how they are already digitizing their case management process. Some of us are trying to work out the concept of doing that. We haven't even gotten to seeing how it can be implemented. So we may find that colleagues in Europe, for example, started these things 20 years ago, 25 years ago. What is it that they can share with us as best practices? So maybe those are some of the areas where we can collaborate with colleagues that are not on the African continent. Whistleblowing is a very critical issue, to which for me, I would like to add the point of when we read most of our statutes, we find that they don't touch on whether complainants can lodge their complaints anonymously. But the kind of probing that we do sometimes is such that our complainants would want to remain anonymous for obvious reasons, the fear of reprisals. So what are the best practices that are emerging? What can we borrow from jurisdictions where the mandates of ombudsman, maladministration and corruption separate? Because I think in those dealing with corruption, the issue of whistleblowing is dealt with extensively and sometimes through the statutes. How best can we protect people that don't want to be known, or indeed our witnesses that would be facing some threats? There was a particular question on how do you go about dealing with an investigation on poor reconciliation of accounting books in this kind of processes. We have a case in point. At the onset of COVID, there was a lot of public outcry of abuse of COVID funds by different ministries, departments, and agencies. We lodged a systemic investigation into that process. It was very tedious. It needs you to be on top of things that sometimes when you're trained as a lawyer and only attended the few lectures on the accounting and finance management, really, you needed to bring in a lot of experts to help you understand what ought to have been recorded, what is missing, and to keep using the powers under the Ombudsman Act to remind the responding agencies that they were duty-bound to provide certain books that they would have been reluctant to provide ordinarily until we finalized that audit. And I think it led now to another follow-up audit by the National Audit Office. And it had its own consequences. People were put on suspension and everything. So it's possible, but it becomes really tedious work, and it may require a lot of expert input or a lot of research for us as ombudsman to understand the subject matter, to understand financial accounting processes, and so on and so forth. Otherwise, I think Madam already responded. I thought I would just add a few thoughts on some of those questions. Thank you.
Thank you. Yes, I think the two panelists have addressed a number of questions. Indeed, as the African Ombudsman and Mediators Association, we have a memorandum of understanding with the International Ombudsman Institute, which then covers ombudsman around the world. It's a global institution, so that's where we can collaborate. And also the recording of this meeting or of this webinar will be on our website, AOMA website. The team from AORC will share that recording so you can still continue benefiting. On using other expert evidence, or how do you manage expert evidence, or when you don't have the skills, we as the public protector of service providers, where we've advertised a tender calling upon all experts to be in our database. And if we need maybe an actuary or any other skill, that's where we can tap in. Though I know we might not have utilized that most of the time, but then that's the expertise which can help us, because you know a lot of our staff are legally qualified. They might not understand the actuary or build technical issues, health related technical issues. So I think by utilizing that, it's very, very critical. So the issue of whistleblowers, we as the public protector, we are a safe haven for whistleblowers, and we protect them, and they can lodge complaints anonymously with us. And the most important thing we say to them, just avail yourself so that when we need to follow up, we can be able to contact you. We have a number of cases in South Africa. Visit our website. You'll find a number of reports we've issued. There's an investigation we did with the appointment of one of the SARS officials who resigned but then rejoined. The complainant there was anonymous. Unfortunately, sometimes members of the media, somebody exposed that person, and it's so wrong, because then once they are exposed, their lives might be in danger. And we also have various investigations we've conducted where we were able to also guard against revealing the anonymous complainants, but also you can, as an ombudsman, if you have evidence, as the program, the facilitator said, how do we make sure, or as well, we've mentioned that, keep the information secured and protect the security of the country, because it's our responsibility. There's one report we've issued relating to the what we call the rogue unit, or the operations of one SARS, South African Revenue Services section, which collated evidence which was contrary to what the law is saying. But then we didn't reveal certain information or equipments which were utilized for security reasons, so we can still do that. So I'm responding to the person who's asking about cases and various case law which is out there, which they can go through. Thank you so much. I think program director or facilitator, I can then thank everyone and close this meeting. You'll get all the record of these proceedings on the African Ombudsman and Mediators Association website. You can also get information from Twitter, from our Facebook page, and then you will be able to learn from this process. And thank you so much, AORC team. You always excel and outdone yourself. Thank you to University of KwaZulu-Natal for availing your services always. You are always there and supporting us in conducting these webinars. Honorable Nirere, thank you so much for taking time. Your information was so informative and we've learned a lot. Honorable Malera, thank you so much as well for availing yourself, and your experience and expertise helped us a lot. Honorable Sanyang and all the ombudsman who are here, all our staff members, thank you so much for this time. Keep be safe, and we follow the protocols. Some countries are still struggling with the issues of COVID, and let's be safe, and thank you so much. Goodbye.
Thank you very much, Honorable Advocate. I think I should, at this moment, on behalf of all the participants to this meeting, congratulate our presenters for the very well detailed, very useful and educative presentations that you've done. I was looking at the invitation that was sent prior to this meeting. And the reason why we have this managing evidence as the theme of this conference was because of the request based on assessment needs of the different countries that a training should be conducted on this very important topic of evidence, managing evidence. I think we've all learned a lot that will help us, improve on whatever we are doing in our respective countries. And I believe at this moment I can say that the goal of this webinar has been achieved, because it has said that this webinar is an excellent opportunity to enhance the capacity of African Ombudsman throughout the continent in their tasks. It will also contribute to the development of skilled resources within the Ombudsman institutions to the benefit of each participating country and Africa as a whole. I think that has been achieved, and we are very grateful for those who compiled this program to bring it to what it is now. And I think the evidence that this is a very successful meeting is the fact that it was planned for 1.5 hours, but we now into 2 hours. So it shows how we are all eager to learn more from our very eloquent presenters, and we look forward to continue to share information, anything that will help us develop our staff, ourselves. And I think that's one reason why this association has been formed. Let's continue to be in touch. And as the chair has said, these documents will be on the website. And for those who have not had their questions answered, again, I think you'll be invited to post them on the website, and at the appropriate time, they'll be answered for everybody's benefit. So with those few comments, I want to thank all of you again, and especially for me to be given the opportunity to facilitate this program. I thank you all.
Thank you. Goodbye.
Thank you. Bye.
Thank you, everybody.
Thank you. Bye.
Bye.
Bye-bye.
Thank you.